So, welcome everyone to this special session. Today, we are launching the Impact Podcast Series, a platform for the IT community covering key topics like immigration, health, finance, entrepreneurship, and more. You'll be seeing a lot of podcasts like this in future. Our goal is to share insights that educate, inspire, and create a positive impact, especially on IT community. I'd also like to take a moment to honor my father on his 75th birthday. Today is his 75th birthday. His values, resilience, and guidance have been a major influence in my life, and this launch is dedicated to him with immense gratitude. For our very first episode, we are thrilled to host Praveen. Mr. Praveen is a founding partner of ILBSG, International Legal and Business Services Group. Praveen is a seasoned attorney with deep expertise in US immigration law, corporate transactions, and global litigation. He is a graduate of Temple Law School in Philadelphia. He is licensed in New York and US federal courts and holds corporate law credentials from India and the UK, giving him a truly global perspective. ILBSG is a premier law firm with 12 dedicated attorneys who exclusively practice US immigration law, providing exceptional legal counsel and compliance services to clients worldwide. The firm's commitment to excellence, client success, and global mobility has made it a trusted partner for businesses and individuals navigating complex immigration process. Before we dive into the main agenda, I would like to invite Mr. Praveen to share a few words, whether about his journey, his passion for immigration law, or anything he would like to add for context. Praveen, over to you.
Thank you, Durga. Thank you for inviting me to the podcast today. I'm equally excited to share views and answer any questions on US immigration today. It's an incredible journey that I had in this country, being an immigration lawyer, uh, been practicing over 20 years right now. So we have vast experience looking at different scenarios, changes in immigration law, and touching different people and different walks of life truly, and will share as much as I can, which would be helpful for everyone. Thank you.
Thank you very much. So, first of all, can you provide a general overview of H1 and L1 visas and identify who they are designed for?
Right. Going back to the basics again, we hear a lot about H1B visas, and in fact, it's so popular that even back in the country, even in India, that people talk about H1B visas these days because it's so popular that it actually allows people to come here to the US and work on specialty occupations. So not all the occupations that they can actually work, but H1B allows people to come here and work in a specialty occupation. What that means is a position which needs a minimum of a bachelor's degrees to work. It's not about the employee having a bachelor's degree or a master's degree or a PhD. It's equivalent that it's important to have the position requirement to have a bachelor's degree. So if there is any position which demands a bachelor's degree as a minimum requirement, then that actually qualifies for H1B position. So considering that, then getting an H1B approval into IT is equally challenging because not all IT positions need maybe a bachelor's degree to work, right? So it might be a vast area where there might be people who are working in specific areas of IT without a bachelor's degree because all you need is coding and logical skills maybe. So not all the positions would demand it. So time and again, USCIS comes back with this challenge asking define this H1B specialty occupation as a minimum requirement for this profession or this job title that whatever we find. So again, any engineering position, for example, being a civil engineer, mechanical engineer, directly relevant to their job titles would qualify for H1B. Uh, it's broad. There are many positions into sciences. Even doctors would qualify, and different other professions. Then for L1B, it's a bit different. That's more as being specialized knowledge. So a bachelor's degree is not a requirement, but again, someone who worked for a parent company or a subsidiary in a different country of a corporation, of a US corporation, would qualify to come here on a specialized knowledge to deliver their services to the parent company on L1B. And of course, the requirement is that they are supposed to be working at least 1 year in the last 3 years to even qualify for that intra-company transfer. So the difference between H1B and L1B is H1B needs the position demands for a bachelor's degree, but L1B does not require that kind of a requirement, that a position can be something which does not need a bachelor's degree, but a specialized knowledge is required. And USCIS defines specialized knowledge into that profession as into the L1B as something that they got a training internally on that particular concept or an aspect of a process that the company follows, and the person has been working on that uh, in the parent or a subsidiary in a different country. So there is a difference between both.
Okay. Now, what are the eligibility requirements for each of these visas and how do they differ?
Right. The eligibility again, as the entry to a H1B occupation would be based on a minimum requirement as a bachelor's degree. The position demands that. So naturally, the employee should have a bachelor's degree to qualify. So the bachelor's degree as defined is a 4 years bachelor's degree. And of course, if someone has a 3 years bachelor's degree, then there is a provision where an experience evaluation might make it equivalent to a bachelor's degree based on the number of years of experience that they have. So that's a basic requirement for anyone to be qualified for H1B. And the position has to be directly related to the job. Again, with the new rules coming up from January 17th, there are advantages that they have actually broadened, saying that the range of qualifying degrees. So the employer might define not just one bachelor's degree, but a range of bachelor's degree degrees which might qualify for that. And there should be a logical connection. That's what they always say between the education, the bachelor's degree that a person has, and the position that he's going to be taking up. So that's the minimum requirement for the H1B. Again, L1B, as I said, it's a specialized knowledge gained by experience working into that particular process, more specific for that company. So if there is a company which actually produces something and they have their own internal process which is specialized for them, and somebody got trained into that process, is what makes them eligible to apply for the L1.
Okay. So could you detail the application process for both the H1 and L1 visas, particularly noting any differences in procedure?
Right. So H1B, again, as you all know, that it goes to the lottery. So every year we have 65,000 for the general and another 20,000 for the master's quota. So we have 85,000 H1s to be given out every fiscal year. Then because we have so many applications, more than 200, 300,000 applications, 400,000 applications at one time, then USCIS has introduced a lottery system where employers will register the prospective employees through their employer portal on the USCIS, and that would begin sometime in March. By end of March, they would take out a lottery, and based on that selection in the lotteries, they will have 90 days to apply for the H1B. And the fiscal year for the USCIS is always April 1st is the application start date. The fiscal year starts on October 1st and runs through the September 30th of the next year. So 6 months prior to the start date, which is October 1st of this year, USCIS will start accepting the applications from April 1st. And prior to that is when they would do the lottery. So it's primarily the lottery, which starts in March. Then the selection process should end by end of March. Then April 1st is the start date of filing for the selected applications. And employers are given up to 90 days to file for the H1Bs. And that's how they are selected. And the employment would start from October 1st so that they have enough time to appear for the visa stamping if they're outside the US, or if they are here, then they would do the change of status and then move along. Then for L1B, there is no quota as such. then its primary qualification is that there is an employer in the US and the employer has a subsidiary or a parent outside the US, and this employee has been working for that employer for at least 1 year in the last 3 years in the parent or subsidiary. Then, in addition to that, he is trained and experienced in the specialized knowledge or a specialized process that the company has for their specific need for the delivery of their product or service. So that's the difference. And we can apply for L1B as long as these qualifications are met anytime during the year.
Okay, great. So before we proceed further, I would like to appeal to the audience in YouTube. So first of all, if you have any questions and if you wanted to get them clarified around H1 and L1, feel free to join Zoom meeting, the Zoom webinar. We have provided the link in the live chat. You can use the link and join. On top of it, I would like to request you to share your feedback about the video. Also, if you like it, make sure to like. And also, we'll be running these podcasts very often on wide range of topics. And if you want to get notified, I would recommend you to subscribe to our channel and hit on subscribe button so that you are notified. Sorry, notification icon so that you are notified whenever we announce any podcast in future. That being said, now coming back to the agenda, what are the key differences between H1 and L1 in terms of duration, renewability, and policies for dependents?
Right. Can you repeat your question, Durga? Oh.
Yeah. So, what are the key differences between the H1B and L1B visas in terms of duration, renewability, and policies for dependents?
Right. So we're talking about key differences between H1B and L1B for the duration first.
Yeah.
So for the duration, you know that the H1B is valid for 6 years. So each time when an employer files a H1B, usually they will be applying for 3 years, plus an additional 3 years after completion of the 3 years, or the remainder of the 6 years period. That's how we have to take it. So the total years, that number of years that a person can work on a H1B 6 years, versus on L1B it's 7 years. Then it all depends then how we are actually applying for that, and what we are actually going to achieve through this filings, right? So especially in the specialty occupation, if they are in the specialized knowledge, if they are actually filing, then that's how we have to calculate the number of years that they have worked in the parent and subsidiary versus, and the H1B period is counted together with the L1B, right? So then the number of years would be 6 years together, right? Yeah. Go ahead, Durga. And what was the other?
And can you elaborate around policies for the dependents?
The policies for the dependents, then yes, the same thing, that they can actually come here. H1B dependents can come here on H4 independent visas. Then for L1B, they actually come on L2 visas.
Okay. And so there are few questions that arise when it comes to the people, right? So when it comes to H1 visas, if we get into the previous administration of Trump, uh, the extension of 3 years or renewal of H1s of 3 years is not a norm, right? It used to be very less. So can you throw some light how these decisions fluctuate between administrations?
Right. Again, as we have already seen, that the current administration is talking more about curtailing on these employment-based visas and making it more stringent. And as they were talking about making it as best of the brightest should actually work in this area, right? So, for example, on a H1B, they think that H1B visas are replacing US workers in most of the situations. So they wanted to make sure that US workers would get more opportunities, and because H1B workers, in their view, that they're not getting paid enough, or they're actually getting paid less, so they make H1Bs more competitive to a US worker. And L1B again is, as I mentioned, it's more specialized knowledge. L1A is for 7 years, L1B is for 5 years. Then these people are already working in their companies abroad, and they're coming here to actually bring that specialized knowledge into this market. So that would actually help the US economy in getting these products, services delivered. So that's how it's been presented. So the current administration, as I said, is more looking forward to make this as more specialized, and not everyone should get this unless they're highly paid, for example, right? So that's what they wanted to prefer, that these positions have to be given out to jobs where these are highly paid and not competing with the US workers.
Okay. So any in near future, do you foresee any changes with respect to dependent visas? Sorry, that H4 EAD. Earlier, it used to be only L2 EAD. Then few years back, H4 EAD is introduced. Now, do you foresee any changes to that, or do you think it will continue as is?
Right. So, putting my personal opinion aside, then there's a lot of debate going on that you have all noticed, right? That how to handle this OPT extensions or H4 EADs. The majority of the people from the current administration would not support anything on H4 EADs or OPT extensions. But there are certain groups which they see the business people, the business community, they see the value of these visas, then how they are actually helping to thrive this economy and creating jobs. So obviously, there will be a difference, but I think, in my opinion, the H4 EAD and the OPT extension would remain for most of the part of this administration too, especially considering the impact that it would have on the economy. Because several thousands and hundreds and thousands of people are actually working on H4 EADs and OPTs in major corporations in different fields, that would definitely make it less competitive for the economy if they don't work.
Sure. Thank you. So, how does the transition from F1 to H1B work, and what should students do to prepare for this transition?
Right. So it's a broad, interesting question that time and again I talk with F1 students who are into this journey, into this transition phase. The F1 students would actually utilize their OPT period, the 3 years OPT period, in gaining the practical experience and working with employers who might sponsor their H1s. So again, it's going through the lottery system. Then obviously it becomes difficult. You don't have to wait until the last minute to apply for the H1B. So it's always beneficial if you can ask your employers to start sponsoring you for the H1B if they like, if they have a bona fide employment, to do that as soon as possible. Because that way you have enough chances to get into the lottery. Then very important aspect is, I always advise students not to be hasty in just getting a H1B. So because the H1B goes to the lottery, then most of the students feel very anxious about it. And even if they are working somewhere, then they might approach some other employers to request to apply for the H1B as long as they have a job offer. So, applying through the lottery and getting selected in the lottery is not a big deal. You might get through that, but actual filing depends on the bona fide employment. If you don't have a bona fide employment, and just for the sake of filing for the H1B, if an employer enthusiastically files for you, that might not really remain, because if there is a site visit, if there is an investigation, then obviously they would revoke the H1B as if it was never been even selected in the lottery. Not only that, that would actually jeopardize your current status, because you have an OPT for, say, next 2 years. Then you got selected through a H1B from another company. 2 years down the line, if you want to apply for the H1B, then you might have to wait for 2 years. So that where they might not have proper documentation to file the H1B, and you end up getting a H1B approval. Then which might get revoked in the next 2 months, 3 months, 6 months, 1 year. The site visits can go after maybe even 2 years. I've seen people getting a site visit even after 2 years after getting selected in the H1B and getting an approval. So by the time you're already working for this employer or maybe move to a different employer, then if the primary H1 gets investigated or there is a site visit with the primary employer who cannot defend your H1B, that gets revoked. That means all the chain reaction, all the chain H1s that you got approved through that would also get denied. So you should not really get into those. Rather, just stick with your plan, go with your primary employer, whoever is providing your bona fide employment, to have them apply for your job.
Yeah, Govardhan seemed to have a question. So Govardhan,
Yeah,
go
I
ahead.
got a question from Naresh Dulam, and he's asking what are the options for people laid off due to organizational changes if they can't find a job in 60 days?
Right. So the practical way to approach a situation where if you cannot find a job within the next 60 days is to find a different status for you to change. For example, if the spouse, if you're married and you have a spouse and he or she is on a H1B, then opt to go for the H4. Then if you have plans to really gain some education or a degree, then if you have not done that before, probably this is the time to consider getting onto a change of status to F1 as a student. Or even as a temporary basis, if your intention is to remain in the US, then probably meet and greet people and wrap up your things. You can always apply for a B1, B2. So when you apply for a B2, then you get 180 days to request to stay in the country. Then that's a change of status from H1 to B1, B2 or B2 application. Then remain in the country, try to focus on your things to wrap up or meet and greet people. But in the meantime, if you do get interviews, you're allowed to take interviews. And the new employer, if you're selected probably within this 180 days, can file for your H1B as a cap exempt since you are already counted in the H1. Then you should always request the employer to file it in a premium process because you're not allowed to start working unless you get a H1B approval, number one. And that we have seen consistently, the policy of the USCIS is to pick up your pending B1, B2 application, approve it before approving the H1B, and consider that as a change of status because for all purposes, if you see a B1, B2 application pending and we are filing for a H1B, it should not be supposed to be, it cannot be as a change of status because you don't have a status, right? What you have is a pending status. But otherwise, USC has considered this as a change of status by picking up the B1, B2, approving it, and then approving the H1B with the change of status and giving you a continuation of stay in the US. So that way you can remain in the country and you can just continue working on the H1B upon approval. So I think that should be the right approach for you. Then unless you want to go back to the school, you want to pick up some education which might help your career, and especially with the new proposed rules coming, if it is going to be a point-based system, someone who has a master's is definitely you can consider picking up a PhD from a US university because that way you get maximum points in the point-based system. And with your experience, and maybe if you end up getting a job offer with good salary, then there's a good chance of you getting into the green card process faster.
Okay, it's really insightful. Means many people don't know all these options and they become very anxious as
Correct.
soon as they got laid off.
And
This is
again,
this is
the
definitely a lot
pitfall,
insightful.
right? And the pitfall sometimes is that hastily, as you rightly mentioned, Durga, that they become so anxious and they find some employer who can file a H1B for them. And that's not the right approach because any H1, anyone can file unless they have a bona fide employment, number one, unless they have sufficient documentation to defend it, that's not going to stay. You're happy for maybe a few months that you have a H1B, but the problems will follow you because you cannot come out of that vicious cycle. If there is a site visit, the employer cannot defend it. We all know it. Then it just goes beyond your control at that point, that you might have a job, but again, the H1B won't stick with you. So again, taking the right decision when you are within the 60 days periods, take a right advice, then make sure that you opt for some option which really goes along with your career goals. So someone going for an F1, I always encourage that because if they pick up the PhD, as I mentioned, then that's really helpful for them in the long run. And you might think that, okay, my other friend got a H1B, selected in the lottery, or someone got into H1B with another company. But when you pick up this kind of an option, it's a long-term goal that it always stands out. Even it helps your career. So consider going back to the F1, or consider going with a B1, B2 on a temporary basis for up to 180 days, because definitely you need that time to wrap up things. But in the meantime, you apply for a job, you end up getting an interview, then you end up getting an offer. There is always an option for them to file for a change of status from B1, B2 to H1. And both are getting approved when you are actually doing that in a premium process, as long as the B1, B2 is genuine and you have sufficient documentation to defend it. Then, of course, if a spouse is on a H1, then H4 is a very good option too. So,
Okay, great. Thank you for reiterating that. So now we'll get to few questions. There's a question from Majid. So the question is, I received a Consular H1B approval from company A and now have an offer from company B. How can I transfer my H1B to company B given that I haven't activated my H1B from company A yet? Do I need to go to my home country for stamping before transferring, or is there another process for Consular H1B transfers?
right. So pretty interesting. Most of the students are opting for a consular processing on the H1B. This being the trend, you are on a F1 and you have an OPT for another year, 2 years, or 3 years, and then you considered to go with a H1B. The employer is sponsoring you. You got selected in the lottery. Then when they are filing, then you said, no, I want to continue on the OPT because you have work permit. It's a good strategy because H1B is for 6 years. Then you are adding 3 more years with the work permit, right, on an OPT. So then you end up actually getting 9 years without even just going on to other conditions for the extension on the H1B. So that straight 9 years that you're utilizing to work here in the US is definitely a good option. So probably that motivates you to actually file for a H1B without change of status or requesting for a consular process, which is good, which is still considered to be selected in the lottery. Then you have a H1B application even though you did not work. But the question is that whether you truly had a job when you got a H1B approval. Because if there is a site visit, would that H1B approval stand out for any site visit is a question. Assuming that is all right, then you can always have employer B file for your new H1B right now, not subject to cap, then can start the H1B anytime during the year. Then you can always do a change of status from F1 OPT to employer A that you are working from to employer B on a H1B. That's allowed because your H1B is primarily considered to be cap exempt.
Okay, thank you. So there are quite a few attendees. In case if you wanted to ask the question or voice, just raise your hand and probably we will let you speak and you can ask questions directly as well. And again, those who have joined the session through YouTube, in case if you wanted to interact with Mr. Praveen directly, feel free to join the webinar. The link is already provided in the live chat and we should be glad to answer your questions.
Naresh seems to have raised the question. I'm going to allow him to talk.
Yeah, sure.
Naresh, you can talk now.
Hey, Durga. Hey, Praveen. Thanks. I have one question around the point-based system you mentioned. You mentioned that there is a point-based system is coming up. So is it for only the people who are studied here or for the experienced people who are working here for more than 10 years, but they never studied here?
Right. We are just discussing hypothetically here. Yes, that's in the proposal that we have seen that kind of documents. circulating around that the current administration aims to get the best of the brightest. That's the policy. So employment-based system again goes through EB1, EB2, EB3, as you all know. It goes through the labor certification. It's cumbersome. So rather, a point-based system might be more easy or best system to attract the talent around the world. So the proposal would be like this, something like this. So if you have a proficiency in English and you can prove that you are in the 90th percentile of the proficiency, then you get number of points. Then if you have a job offer in the US from an US employer where you get 300% of the median wages of the state that you are going to be working. For example, you're working in Texas. Then the median wages, for example, in Texas might be anywhere, say 85,000 or 88,000, say even 80,000. So then 300% of 80,000 is a median wages in the state of Texas. 300% might be say 240,000. Then if you have a job offer, then you're going to work in a job where you get paid that money, then you might get maximum points. And somebody who is getting 200% of that median wages might get a less number of points. Then if you're getting 100% of that wages, you might get some basic points. So when you put all this together, including your age, if you are between say 27 and 31, then you get maximum number of points. And somebody is 25, then they get less number of points. Somebody is 35, then they get less points. Then somebody has a PhD from a US university would get maximum number of points in the education category. So when you sum up all these points together, you are required to get at least minimum of 30 points. Then you qualify to apply for the immigration. Then from the pool of these people who applied, who qualified to apply for the immigration, they might invite people with more number of points. So somebody has 37 points, then they get invited first versus somebody has 32 points, and somebody who has just 30 points to qualify might not get, because the number of people that they might invite per fiscal year might be limited to only say 140,000 visas. So that way, the best of the brightest from the entire world will come. But again, students who studied in the US might get an advantage, because any education from the US university is always preferred and they are giving more number of points. These are all proposals. Again, there's nothing solid that we can bank on or we're discussing, but this might be a route that the current administration might be adopting or discussing, debating on this to introduce something, which probably might solve a lot of the issues that we see currently, but at the same time might create new challenges for the immigration.
Thank you.
Yeah, let's go back to the agenda and we'll take questions once again at a later point in time. So can you discuss the recent H1B modernization rule? Yeah, you already know there's a lot of buzz around that. So if you can throw some expert insights into that, it will be great.
Right. So how to prepare ourselves starting January 17th. So the modernization rule has a lot of benefits for the employer, but at the same time has brought in some restrictions for the employers. So let's talk about the restrictions maybe to start with, then we'll go to the benefits for everyone. So the restrictions that, as I see, in my opinion, they codified certain policies that USCIS has adopted previously and has to withdraw for various reasons. And now they came back with codifying those requirements. For example, they say that the range of degrees are allowed. That's an advantage. But especially in a H1B consulting scenario, if someone is working at a client site, at a third-party client site, then those requirements has to be coming from the third-party client. Then the employer claiming those are probably not valid for USCIS to approve the petition. So if someone is working at the client side, then the job requirements have to be mentioned by the client. That means we need a client letter. So the client letter also has to be in a certain format that explains about education requirements and their minimum requirements to hire someone into that position. And they might even list out the range of degrees, the range of fields that they accept into that particular systems analyst, for example. A systems analyst, then they might say that we accept people from various walks of engineering degrees like electrical, computer science, then those kind of things, as long as they have relevant experience. So I think that indicates that client letters might become important. So that's what is going to be coming back. Then certain areas like artificial intelligence and other things cannot pinpoint a particular area of education, right? Because they are saying that it has to be directly relevant for the field. I don't know what field is relevant for AI, honestly, at this point, because it's so vast. And that might pose some challenges for employers who are filing positions specifically into AI, maybe. So we'll wait and see. Then advantages are, as I said, that they are accepting a range of degrees to qualify for the H1B. And USCIS is also saying that normally requiring bachelor's does not mean that you always need a bachelor's degree. So positions which probably does not people does not work using a bachelor's degree might also qualify for H1B. I'm just talking about the positions. So a position which normally does not require a bachelor's degree might also qualify. So it's broadened. Then we have chances where we can try for some new positions where they might qualify for the H1B. And it was too restrictive in the current administration. So again, for cap gap, if you have seen for the students, it's really beneficial. So what they're saying, they are extending the cap gap till the April of next year. For example, someone actually got into a lottery this year in April. They got selected, and their H1, their OPT is expiring in, say, June or July. They were allowed to actually continue working until September of 2025 earlier, but now they're saying that you can work until April of 2026, maybe. Or if that is denied, the H1B is denied, and the employer is challenging that, if they have a means to go with a motion to reopen or an appeal, they can still continue to work on OPT. So these are really beneficial for students in the modernization rule. So there are certain benefits as we discussed.
Great. So what recent policy changes have affected these visa types, and what trends have you noticed in visa issuance statistics?
Right. In the last 1 month, we have seen a lot of visas getting into 221Gs where they need administrative processing. That's probably because of the issues which are stemming out from the H1B approvals itself. Because as I mentioned, prior to the modernization, USCIS has approached mostly post-application, post-approval review. So when an employer files for an application, H1B petition, then they have given the details about the work location, or specifically they might not have elaborated on the requirements, or they did not really present that evidence that they have a specialty occupation related job, a bona fide job available with an employer. So someone just simply filed with an LCA with some basic details might also got approved. We hear this all the time. But that doesn't mean that that approval is going to stick with them. Then there is a site visit and there is a rejection. But in the meantime, if someone goes for the stamping, they have figured out this trend and they are actually issuing a 221G. What that means is they are motivating USCIS to go for a site visit, number one, by approaching them, by doing that administrative processing, by internally raising these questions for the USCIS, or tipping USCIS to verify this information and come back to the consulate, or consulate themselves, the Department of State themselves, approaching the employer via email or phone to verify the employment and get more details so that they know the clear requirements and then approve it. So we have seen a lot of 221Gs randomly in the last few months, and at least for the last 1 month, we have seen the trend. So anyone who is going for the visa stamping, number one, you got to make sure, even though at the time of the filing, there is no requirement for you to carry a client letter, consider carrying a client letter now. And consider mentioning in the client letter that you are actually going on a vacation and there is a position available and you're expected to return on certain dates. Why? Because if I am the consular officer looking at your application, then obviously I want to verify that if you still have that position available with that client, whatever the client that you have mentioned. So that's what motivates me to go with the 221G for an administrative processing, so that we can go and approach the client or the employer to verify this information. Rather, you bring a client letter which is currently dated and clearly mention that you are on a vacation and you are going back on a certain date, would give me enough assurances to think that yes, there is a position available, he is on a vacation, then there is a position available when he even goes back. So at least you are trying to make my job easy. Then if you have not considered having a client letter by filing a H1B, because that was not a requirement at that time, but now if you are going for the stamping, make sure that you carry a client letter with all the details as much as possible, so that makes the verification process easy. And that has avoided a lot of 221Gs in my experience with a lot of clients that I deal with, because I insist, I explain them, we work with them, we make sure that they're carrying these letters. And the proper language is important, so that that helps the officer to overcome any questions that they might have, whether the position is still available or not. So I think that's the current trend, and that would be the approach going forward too.
Great. So one of the questions I often get, because I'm a veteran in the industry and I have so many friends who are more than 10, 15 years of experience, right? So I often hear about self-sponsored H1, and you told in the beginning assertively that H1B is supposed to be employer-sponsored. So can you throw some light around this concept of self-sponsored H1 and the impacts that can have on one's life?
Right. Yeah. So it's pretty important move. Then I was reserving this to the end so that we can discuss more about this. And this is what probably most of our audiences are waiting to hear. That what is this self-sponsorship? Then how can we self-sponsor a H1B more like an entrepreneur visa, encouraging entrepreneurs to come to the US and do this. So again, we have to wait for the details as we dive into this program. But as it is designed, the policy itself is to encourage entrepreneurs to come to the US, then innovate. Then even if someone has majority stakeholding in their companies, they would be able to hold the H1B for that company. So let me give you an example. And these are all codified, and this was already there previously, but maybe loosely administered, or not many people know about it. So let me give you a vague example and explain you how this might happen. So there are, say, a group of students in MIT. So they have come up with an invention, they have filed for a patent, then call it a product or a service and application, a SaaS product that they have come up with, and they got the patent. And some of the students of this group are on F1 visa. Then they approached a group of investors, and they saw this as an excellent idea, and they maybe invested $10 million. Then the students who own the patent have transferred that to that company, and in turn, they got majority shareholding in the company. So there is $10 million on the table. There is a patent for the company which has been transferred. Then in turn, because they transferred the patent, they got majority shareholding in the company. And because they are an F1 visa, now they need sponsorship for the company too. So they ended up actually getting a sponsorship. This is true. This has happened in the past. That there is a board of directors. There are board of directors, and there is a proper organizational hierarchy in the company. There is money in the company. So they can separate the employer and employee relationship at that time, and they could actually file a H1B for that F1 students, and they could actually work for the employer for their own company where they are holding the majority shareholding on a different role as a software engineer, as an architect, or someone. But at the same time, they also hold the majority share. So the similar way, if you actually take it in the current scenario after the modernization, that is still possible in the same way. The concept is the same. That's exactly how they want you to do it. But you can always sponsor yourself and incorporate a company and do it, even sometimes not having that kind of investors or the board. but you end up getting the H1B approval only for 18 months. So it is driven more towards having an entrepreneur doing it. And we get a lot of calls. I've talked with several people saying that, hey, can I actually incorporate a company, sponsor other friends of mine? Then I can find a job with them for a third party. Can I do H1B consulting into the same scenario? Per se, my opinion would be difficult. A lot of challenges in doing that. And I don't deny that they are specifically addressing that you cannot do it. You can probably, but there are a lot of challenges in that. That's not meant for that. This is meant for more towards being an entrepreneur into an innovation where you bring a product or a service and then help the economy. So yes, you can sponsor the way that I explained. If there is a product service that you are an innovator and you hold patents for that, or you hold a majority shareholding in that company, or you invested money even. Somebody does not actually hold a patent, but they invested money into that company and they can hire some people and they sponsored themselves into that. But what is very important is to make sure that the H1B still sticks as a specialty occupation, right? You cannot be someone without working into the specialty occupation where bachelor's degree is not required. For example, an operation manager, that is always challenged for the H1B. You cannot just call yourself as an operation manager, hold majority shareholding in the company and sponsor yourself. Because you can sponsor, but the position itself is being challenged, whether it qualifies for the H1B or not. So when you pick up something which is qualifying for the H1B, then obviously you need different people to do different things in your company. You cannot be doing all those things. You are restricted to do only the job duties which are confined to your specialty occupation, which probably is as a software engineer or as an architect. You cannot be just talking about hiring people, because hiring people, you need another person who will do it. But yes, you can actually always do it. But again, working for a third party client, sponsoring yourself might make it more difficult if somebody is considering it. That's something that you have to wait and see how USCIS comes up with their interpretations on these things and take it up. Per se, it's not, I cannot say that it's not allowed, but that's not something that it's not meant for.
Okay. So let's see if anyone have any questions. Audience, if you guys have any questions, let us know. I think, Govardhan, do you see any questions on YouTube?
No, I don't see anything on YouTube.
Yeah, so anyone who are attendees have any questions here before we wrap up? I have one more question though. After that, we can wrap up. But before my question, if anyone have any questions, yeah, I think someone raised the hand.
Sarath has, Sarath, I have unmuted. You can unmute and talk.
Yeah, I have a question. So I'm currently on a H1B visa and employed by my company. I have a passion for filmmaking. I did a filmmaking program in New York Film Academy. And if I have to work part-time on my passion, right, can I really do it? Would it affect my H1B status? Would it violate any of the conditions that I have on my H1B?
As long as the position, the concurrent employment that you want to take it as a part-time. So you're allowed to work on concurrent employment, right? So
Yeah.
a concurrent employment is that you parallelly work at the same time with two employers. So you're working with employer A, and employer B has also is also willing to sponsor or give you a job. Then as long as you are in right terms with employer A, your employment agreement allows you to do it, then you can always get sponsored with your employer B. Immigration has no restrictions for you to work for multiple employers at the same time. As long as one of these petitions are filed as concurrent employment with, maybe it's part-time in your situation that you are mentioning. But if an employer is sponsoring that, then it has to be a specialty application. So again, you are an IT professional, but you want to actually work in the movie field, and you need to pick up that particular job title which qualifies for H1B, right?
Yeah.
That's more important.
So my thing is, right, so generally if you have to work in any of the film set, you have to have you should be getting paid, right? You can't really work without pay because there are some wage laws that each of these production houses has to adhere to minimum wage requirements. And as a H1B holder, right, I can't get paid from other employers. So that is becoming difficult for me to find any of the
Right.
opportunities.
Right, because you have to go through the LCA, right? The H1B has that protection. That's a whole point, because you cannot compete with the US worker. Then employer has to file an LCA agreeing to pay for the minimum wages as per that particular job title, and that's how it goes. Then you cannot be working without payment, and there's no exception for that, unfortunately. And if you are
Thank you.
to get a H1B, and that's the way to go. That employer has to pay you.
So before I get to the final question, I just want to mention that for all those who have listened to the session or attended this session directly, this session is for participants to understand the applicable laws and regulations in general and not specific to any particular issue or situation. The discussion doesn't create a attorney-client relationship, and we suggest making a separate appointment with Mr. Praveen so that you can discuss anything specific or more in detail. So Naresh and Sharath and anyone, if you guys have any questions, I have provided the details in the description of the video on YouTube. You can always reach out to us at support@itversity.com, or you can go to bizlegalservices.com contact. That is the link. You can always reach out to them and take it forward.
And before we wrap up, Durga, again, I want to just touch base on one particular scenario that I hear time and again. Someone who is on L1, and especially in this topic that we were only discussing on L1B, right?
Mm-hmm.
So someone who is here on L1B, then we all know that the duration is 5 years that they are working here. Then someone gets sponsored by the same employer, saying that it's going to be 5 years ending soon, then they might actually get into the lottery. When they go into the lottery, they get selected, and by the time they might have already spent 2 years of their L1B period here in the US. So then when they get selected, then L1B and H1 together would be the 6 years period. So instead of 5 years on the L1B, now it will be 6 years, right? Because they switched to H1. Then in the H1, we also count the L1B period towards this duration, and he ends up getting only 4 years of H1. So each time they get 3 years, and he gets 1 year more, 1 more year of extension. So L1 and H1 together, we have to count when they actually switch to L1 to H1. This is one scenario that they always come back and they seek help, saying that, okay, how can I calculate? Because if you go outside the country on L1B for 1 year, then the clock will reset, and then you can come back for another 5 years, right? L1A for 7 years, L1B for 5 years. You can always go back to your home country, then work there for 1 year, then you are still eligible for the fresh start. Then if you're selected in the H1B, then you have to only calculate based on the number of years that you have worked on L1 and H1 together. So that's how the transition happens. So you don't get a fresh 6 years restart here.
Got it. Got it. Yeah. Before I get to the last question, I would like to reiterate that this is the first session in the series, and we'll be having a lot more sessions, especially on US immigration, be it green card or be it probably specialized visas, whatever it is. I'm not expert to use right terms, but yeah, we are planning to host multiple podcasts. In case if you wanted to hear on specific topics, feel free to use comment section and let us know what you want to hear about, and we will definitely host more sessions like this in future. That being said, again, going back to the self-sponsored H1, I'm talking about a different scenario. The scenario is someone who is a friend of mine sponsoring H1 for me by taking money from me. That is also I consider as a self-sponsored H1. In the beginning, you have mentioned that H1 is always employer sponsored, right? So I'm a little bit confused whether this concept of self-sponsored H1 is possible or not, where I pay money to someone and get H1B sponsored.
No, that's not what it meant. The self-sponsored is that I sponsor myself.
Okay.
It's not like you get sponsored by approaching someone, by paying someone. That's not the idea. That's totally
Is
wrong.
it legitimate at all? Can someone do that?
No, employer can never take money to file a H1B because it's supposed to be a bona fide employment for the need for the company. Then someone paying for the H1B to get sponsored or even requesting an employer to just support for the sake of it is totally wrong. And that's exactly what the scenario that we discussed in the beginning of this session, that anxiously some people approach and thinking that getting into a H1B is sufficient, then I get a spot into that. And an employer who is enthusiastic might have a startup, then does not have a job in hand, but still puts them into the lottery. Then that's wrong because you are attesting saying that you have a bona fide employment when you are submitting someone for the lottery. And they don't read through that language because the language is more restrictive and it's going to penalize whoever is submitting a frivolous petition of frivolous registration for the lottery. Then they get selected. Then they don't have a bona fide employment, still end up sponsoring filing the H1B. Then even if it gets approved, still it's going to be revoked at a later point if there is a site visit or an investigation. So you should never do that. And just paying for that H1B sponsorship is illegal, and that has its own implications for the employer and for the employee too. You might get even banned not filing for any other work permits doing this. So that's not the idea of self-sponsorship. The self-sponsorship here, we are talking about an entrepreneur who incorporates a company, holds majority shareholding in that company, then still he has a role as an employer. See, earlier we used to talk about employer-employee relationship. So unless you define that there is a separation, then you cannot hold a H1B with the same company where you have financial interest. But that's not been clarified right now. And you can always have a majority shareholding in the company. You can have 51% shares in a company or 70% shares in a company. Still, you can work for that company as an employee, but as long as it is a specialty occupation, and that approval is given only for 18 months primarily. So that's what it is. So the example that you should always explain students, that they always talk about innovation. They see something and they can make an app, they can make an application, and they say that, hey, I want to do this product and a service. And because I'm an H1B, I'm not able to do it. No, pool some money, incorporate a company, hold the majority shares of that company, then get sponsored with that company. Okay, then work into that specialty occupation role, which is an IT job. It can be a software developer, it can be an architect or someone that is more specialized for that. Then put money and hold majority shares and have other people put the money. Then you can just recruit people and do it. That's the whole idea. So if you are an innovator, then you don't have to look for any sponsorship. And if anyone is sponsoring, they would only sponsor for their jobs, right? If I have a company, then I'm trying to sponsor a H1B that they are supposed to work on my business, right? Not your business. Then now you have an opportunity. If you are an innovator, you can actually incorporate a company and do it. And in that context, even on OPT, you can actually do this. You can always have an optional practical training. You can incorporate a company and you can actually work on assignments, contracts getting from third parties and still retain your OPT status. But as long as you can actually define, you can actually show them that this is the status, these are the tasks that you've been doing, then an OPT, it is possible for you to actually self-sponsor even prior to this rule. Now it is getting extended to the H1.
Got it. Yeah, thank you very much, Praveen. I think that's it from my side. If you wanted to make any closing statements, feel free to do so. Then we should be able to wrap up today's session.
I think we had a good starting discussion to starting from the basics till until like we got into the H1B modernization and the new changes that we were already seeing for self-sponsorship and all. Then any questions, probably even during the session until the next session, people can actually send their questions and you can collect them, and maybe we can come out with a topic which is more useful for everyone. In this session, again, summarizing it, we discussed about the basic requirements for the H1B. If someone is attending this session from India or abroad, then understanding H1B requirements, and you should not be paying for someone for registering into the lottery or H1B sponsorship. And self-sponsorship does not mean that you have to pay someone and then get it done. Then it's for you to actually sponsor yourself, incorporating a company. Then on an L1B, it's a specialized knowledge that's an intra-company transfer between a parent and a subsidiary and affiliate, as long as you're working in the home country for 1 year in the last 3 years in that specialized field as a specialized, got training into the specialized area. And the duration when you come to the US is 5 years. And for L1A, it's 7 years, but for L1B, it's 5 years. And for H1B, it's 6 years. And you have to always see that someone who is on L1 here in the US now gets sponsored, selected in the H1B, then the L1 and H1 period together would be counted towards the H1B 6 years max out period. So you got to be cautious on that. Then so that you can plan your next steps, getting sponsored in the PERM I-140 and getting the H1B extended. Then you should not think that you have restarted your clock. The restarting of the clock happens only when you go outside the country on L1, stay there for 1 year and then come back. So at least these are the things that we have discussed today. Just for clarity, I'm summarizing again. So
Great. Thank you very much, and looking forward for more sessions like this in future. Thank you.